but I also want to say a huge thank you to Sonia, who has been a fantastic advocate for women's rights in Parliament, and I think we're all very, very lucky to have her. We're also very lucky to have Labour Women's Declaration, who have been working constructively with the Labour Party on the issue of women's sex-based rights. So thank you so much to them for hosting this event and bringing us all together. So what I wanted to sort of use the few minutes that I'm going to talk today was really to talk about why I and many others, including senior equalities lawyers, think that the Equality Act needs clarifying to make clear that sex in the Equality Act means biological sex as opposed to any other definition of sex. That the reason why it's so important is that there's a huge amount at stake when it comes to the clarity of law and what the law means to providers, some of them very small, providing services on the ground, and their ability to know when it's lawful, and in fact when it may be unlawful. So when it's lawful to provide single-sex spaces, sports and services for women, and when in fact it may be unlawful not to make that offer available to women. So to explain that, and apologies if this gets slightly technical, I actually spent this morning swatting up on the Equality Act on Michael Foran's very good policy exchange paper, because it is so complicated, and even though I've written about this issue several times, I always have to swat up on it if I'm going to be writing about it again or talking about it. But to start off, I just need to explain the Equality Act. I'm sure lots of you are very familiar with it. The Equality Act was a landmark piece of legislation passed by the Labour government in 2010. It's something I think that the Labour Party should be incredibly proud of. It brought together a lot of existing legislation and created new legislation and new rights. And really, it's the place in law that sets out protections against discrimination on the basis of 9 protected characteristics. One of those protected characteristics is sex. That's what provides rights to women, and also indeed men. It's not lawful to discriminate against men unless you've got a very good reason. Another protected characteristic is gender reassignment. That's a protected characteristic that quite rightly provides very robust protections against discrimination for trans people. And indeed, I think it's really important to note that the UK is actually a leader when it comes to trans rights and protections against discrimination when you compare it to other countries, for example, the US. A third of those protected characteristics is sexual orientation. And what the Equality Act does, it makes it unlawful to discriminate against people based on those characteristics, but it also sets out the circumstances under which it's lawful to provide single-sex services, spaces, and sports. And then it does kind of a range of other things, which I won't go into. So you might think it's simple because the Equality Act has sex as a protected characteristic. But the big question and lack of clarity in law at the moment is, what does sex mean? So does it mean somebody's biological sex, so whether you're biologically male or female, or does it mean what's termed as your legal sex? So to understand that, there's another piece of legislation which I'm sure many of you will also be familiar with, called the 2004 Gender Recognition Act. It predates the Equality Act by 6 years. And what that piece of legislation does is give people the right to change the way they are treated, so to be treated as though they are of the opposite sex in law for most but not all legal purposes if they go through a gender recognition process. And the lack of clarity in the Equality Act is the protected characteristic of sex. So does female extend to people who are biologically female, or does it also include people who are male, who've been through the gender recognition process and got a certificate that says, for most, but not all purposes, so certainly not for inheritance, but for most purposes in the eyes of the law, they should be treated as though they were female. It doesn't change their actual sex, it changes the way they should be treated in the eyes of the law. And we don't know, basically. There's no clarity in the law on it. On some readings of the Equality Act, it defines a woman as a female of any age, a man an adult female of any age, a man as somebody male. But because we don't know what male and female means, that opens the door to ambiguities. And we know that. How do we know the law is unclear? First of all, very senior lawyers argue about it and what it means. But also, there's some very important cases making their way through the courts. The best that we've got to go on so far is a ruling from the Scottish courts, which says that sex actually means legal sex for the Equality Act in most cases, except where it doesn't really make sense. It's not a very satisfactory legal ruling, but that is now being appealed to the Supreme Court. We expect a ruling on that later this year, potentially next year. I'm just thinking where we are. And we're not quite sure what that ruling is going to say. Lawyers that I've spoken to, it's very hard to predict what the Supreme Court's going to say in any case. Obviously, the best case scenario is, from my perspective and many women's perspective, would be that they come out and say sex means biological sex. The lawyers I've spoken to say it's far more likely that we might get a ruling which says, where basically the Supreme Court bounces it back to Parliament and to MPs and says, look, the law isn't clear on this, it's a problem, but actually it's not for us to determine. Parliament needs to make this clear. So a lot of people think that that's the most likely outcome. Why does this matter? Well, it comes back to what I was saying about understanding the parameters in law around single-sex services, spaces and sports. It's also really, really key for the protected characteristic of sexual orientation, which is determinant on the definition of sex, because the same-sex attraction mean that if you're female, you're attracted to somebody female, or does it mean you're attracted to somebody who self-defines as female? That's a very, very key issue for a lot of lesbians that I know and speak to about this. And what we do know is that if the Scottish courts have got it right, which is that sex means legal sex, not biological sex, that changes the parameters around when it becomes lawful to exclude people who are male but who identify as female from female-only spaces and services. And it's quite technical. I spent a lot of time talking to lawyers. In fact, lawyers actually disagree about the precise legal meaning, but many lawyers think it changes the legal threshold at which you can exclude somebody male who identifies as female. So if sex means biological sex, it doesn't matter whether somebody male has a G or C or not and identifies as female. It is the same threshold to exclude them. And actually, it's quite a simple legal threshold, because we know under the Equality Act, it's legal to provide female-only services. In fact, in some cases, it's probably unlawful not to offer a woman, for example, a rape survivor who says she wants a female-only service. It's probably unlawful in the law not to make a female-only service available to her if you're able to do that resource-wise, etc. So it's much simpler. If sex means legal sex, it becomes far more complicated in law for a small service to show that it is lawful to exclude somebody male who's got a GRC who identifies as female. And what we know is that actually in a world where you've got organisations like Stonewall who've been going out and misinforming about the law, they've been telling services that actually, to be compliant with the law, they need to organise services based on gender identity, self-ID, rather than someone's biological sex. So there's a lot of misinformation about the law. There's a lot of confusion. We've got a history where actually, in the past, if you look at some of the guidance from the statutory regulator under its old leadership, that isn't really legally accurate either. The HRC is in a far better place now, but huge misinformation out there, and services are scared about getting sued. So what it means is that it makes it much, much more difficult to justify providing single-sex services because the law isn't clear on it and people are scared of getting sued. But it does really put a small charity between a rock and a hard place, because it may well be unlawful for them not to provide female-only services as well for women who want and need them. And there's a very important case that's making its way through the courts at the moment in Brighton in relation to the Survivors Network, where a female survivor of sexual violence is suing, I think it's Brighton Council, it might be the charity itself, I can't remember which one, but suing them basically on the basis that it was unlawful for them not to make some form of female-only service available to her. And this is really substantively important. I don't need to explain it to women in this room, I'm sure, but it is a matter of women's basic rights, privacy, dignity, and safety, that if we want to access female-only services where we are vulnerable, where we are undressing, where we are at risk, that we should be able to do so. That is something that is very, very clear for me and a lot of women that I know. And so that confusion in the law really does need clarifying. There are other things that it affects as well. It's not just single-sex spaces, services and sports. There are also provisions in the law, for example, for single-sex associations, which actually, if sex means legal sex, you would not be able to exclude somebody from an association who is male and had a GRC and identified as female from that association. The law doesn't make that provision. So it's a possibility with services, it's not with associations. What does that mean? It means that if you're operating a lesbian-only membership organisation, maybe it's like a big lesbian-only reading group, for example. If you've got somebody who comes along and says, I may be male, or it's obviously male, but I've got a GRC, I'm legally female, you basically cannot exclude someone male from your lesbian-only membership association. There are also huge implications for women who want to access single-sex intimate care. It becomes much, much more difficult if sex means legal sex in the Equality Act. It also becomes more difficult, for example, for a woman in a prison to refuse a strip search from somebody who is male, a prison officer who is male but identifies as female and has a GRC. So these are really, really significant rights for women that are under threat if the law is unclear. What makes this even more urgent and even more important? So far we've sort of muddled along. There's a lack of clarity about the law. It is 100% affecting some women on the ground. We know that. But there aren't actually that many people with GRCs because of the way that the process works at the moment. The thing that has really thrust this into the spotlight has been the lobby to reform the gender recognition process to make it far easier, a form of self-ID. So we've seen that debate play out in Scotland. We've now got the Labour Party, which has actually moved back from that position, which I think is a really fantastic thing, and that is down to the work of a lot of women, including in this room. But there are still questions about what Labour's agenda for the gender recognition process are. So they say they want to demedicalise it. There've been suggestions around, for example, of having only one doctor sign off. Essentially, it could become self-ID by the back door. So this is still a very much a live issue, and the law is not in the right place anyway. We've now had an intervention from the EHRC about a year ago that said that on balance, they looked at it very carefully, it's a very neutral letter, I really recommend reading it, but on balance, the law should be amended to become clear, because unclear law is bad law. People need to know and they need to understand what Parliament meant when they're reading the law. And that's true if you're a really big organisation, but it's also true. I've got a friend who offers a writing course once a year, residential writing retreat, and it happens to be for women, many of whom are survivors of severe sexual trauma. I've just realised I've not got much time left, so I'm gonna finish up soon. And she's a one-person operator, and I introduced her to a lawyer, she sought their advice. I mean, it wasn't formal legal advice, but the answer was, yeah, it is unclear and you would be at risk of being sued. So it has a chilling effect. It prevents people providing services for women. So that is why the law needs to be changed. And just the very last thing I want to say is that Labour's existing position is legally illiterate. It says that it wants to protect single-sex spaces for women. It does not acknowledge the lack of clarity in the law. It's pretending that the law is clear, even though we've literally got a pending case with the Supreme Court because the law is so unclear. And it says, well, we do believe in single-sex spaces for women, sometimes called safe spaces, which is not the accurate term, but we're going to fix it through guidance. That is legally illiterate. The law is the law. Parliament makes the law. The courts interpret it. It matters what the courts say about this unclear law. What the government issues in statutory guidance is irrelevant. The government has to issue it in relation to how the courts interpret the law. So it is just plain wrong for Labour to say there is no issue here, it doesn't need clarification, and we can fix it through guidance. It can't.